You may have heard in the news in the course of this week that there cannot be an arrest without a warrant. And long before this week, there have been discussions, particularly dominated by politicians, where they say there cannot be a search without a warrant. Definitely, there can be an arrest without a warrant, and there can be a search without a warrant. But what are the circumstances when there will be an arrest without a warrant or a search without a warrant? Institutions that have police powers can effect this. Those who do not have police powers, what are the limitations that they have? The other day I read in the news somebody saying that if you came to my home to arrest me without a warrant, I will shoot you. Can you do that? Can you defend yourself or resist an arrest? We'll teach you how to resist an arrest lawfully, not by shooting. Be right back to deal with these very important issues. This is the law. It is your help law. It is your legal light. I'm Samson Ladi Anyanini. You're welcome back. This is the law. It is your legal light. It is your help law. And I'm being joined by Daniel Krang. And Daniel Krang is no stranger to this platform. You would know him very well, that he's been on this platform many times. Daniel Krang is a legal practitioner. He's based in Sunyani, and he has written, I think now we can say over a dozen or so of legal texts, books that lawyers read to educate themselves and to help in the business that they conduct in our courts. Daniel, thank you once again for joining us. Please unmute your mic.
Hello, Samson.
Clear. I can hear you very clearly now.
Thank you very much for having me this afternoon.
Great. And also joining us is Samuel Apiadakon. He's Director of Strategy Communications at the Office of Special Prosecutor. So we're going to have a practitioner and a teacher of the law, and someone who has also who has practiced, has taught the law, but is now in the criminal enforcement operations himself. Two worlds we benefit from. Sammy, thanks for joining us. Hello, Sammy, can you hear me? Please unmute your mic.
Thank you, Samson. You're welcome.
Great, great, great. Good to have you. So, as you have seen our flyer, we are asking the questions, including whether a member of parliament can be arrested without recourse to the Speaker of Parliament. But let's put the MP's matters somewhere first. Let's begin with the questions of arrest. What constitutes, a proper, so to speak, a lawful arrest, and what will constitute, what will trigger, and how can you, as it were, resist an arrest lawfully? Daniel, help us understand. At what point can anyone say we are resisting an arrest?
Thank you very much, Samson. And a very good afternoon to your viewers. Now, before we talk about the power or the right to resist arrest, we have to look at what arrest means in the first place. Now, anybody who is alleged to have committed a crime or a criminal offense is liable to be arrested by either the police or any person exercising the power of arrest or even a private citizen. Now, when we say arrest, we are talking about the legal process of bringing a criminal suspect before the court or before the law. So arrest essentially has to do with somebody taking legal steps to bring a criminal suspect to submission so that the law can apply to him. Under the law, arrest is supposed to be made by touching the body of the person unless that person has submitted to oral arrest. So when the police tell somebody that you are under arrest, orally or verbally, that person is by law required to submit to that oral arrest. If the person does not submit, then the police or the person effecting arrest can now proceed to touch the body of that person in order to bring the person under control and to produce him before the courts for prosecution. Now, under the Constitution of Ghana, every person has the liberty or the freedom to move to any place that that person likes. And so when a person is exercising the power of arrest, that person must ensure that he exercises the power of arrest within the constraints or the confines of the law. Now, a person has the power or the right to resist arrest if that arrest is unlawful. What that means is that we have a procedure for proper arrest. So if the arresting officer does not follow the due procedure or the due process laid down by law, then the arrest is unlawful. Please let viewers get the meaning of unlawful arrest. It is not when you think you have not committed a crime. It is not when you think the allegation against you is unfounded or untrue. It is not when you think you are not guilty. It is when the procedure taken to effect your arrest is not in conformity with the law. And what that means is that the law says that when a person is to be arrested, the arresting officer must inform the suspect in the language he understands the reason for the arrest. So when a police officer is coming to arrest you in your house, he has to first tell you why he's arresting you, the crime you are alleged to have committed. If he fails to tell you this, and he touches your body or he effects your arrest, that arrest is unlawful because it was not preceded by a clear notification or explanation of the alleged wrongdoing or crime against you. Now, an arrest may also be unlawful where the police employ undue force, so that you realize that the arresting officer is essentially not enforcing the law, but he is committing illegality against you. He is brutalizing you in a manner that does not accord with law. So you can say that this person is out of the way and is doing what is clearly an illegality. So the law will permit the suspect to also take whatever reasonable measures to ensure that that illegality does not continue in relation to him. So the right to resist arrest means the right of a person to use every means possible to avoid being unlawfully arrested, to avoid being illegally detained or illegally arrested. And that is a matter of constitutional right.
I need you to go over something again because it is very important for the education of our viewers. You are saying that you cannot claim that or attempt to say you are resisting arrest because you feel that the purpose for which you are being arrested, you have not done the thing that you are being claimed to have done. But you can only resist the arrest if the procedure by which you are being arrested is not compliant with what the law has set down. I need you to go over that again for our education.
Thank you very much, Samson. Let me say that whether an allegation that a person has committed a crime is true or not is a question of law to be determined by the court. That cannot be determined at the point of arrest. So nobody can claim that I'm not submitting myself to be arrested because I haven't done anything wrong. When you do that, it is wrong. You don't have the power and the right to do that because we are not trying you at the time you are being arrested. That is for the court. Now, when the police is coming to arrest you, it is a matter of procedure, a process that must be followed. So when the process to be followed is not followed or complied with, we say the arrest is unlawful. So unlawfulness of arrest is a question of procedure and not a question of the veracity or otherwise of the allegation against you. And so when the police come to say that I am investigating a case of murder or a case of rape against you, and so your presence will be needed, so you are under arrest. We are talking about two things here.
Say I haven't raped anybody, or I haven't committed a murder, or I have not stolen. The things you are saying against me, I have not hit anybody, and therefore, if that's the reason you are coming to arrest me, I am not going. You can't take me away. That's what you are saying.
Nobody has the right to say that to an arresting officer, that I haven't done anything wrong. You don't have the right to say that. But you have the right to say that, okay, I am submitting to arrest, but the process you are employing or the way you are arresting me does not accord with the law, does not accord with the procedure laid down under the law. And so what you are doing is wrong, procedurally speaking. Procedurally speaking.
We'll invite our viewers to, those of you who are, I think now the Constitution is available even by just picking your phone. If you Google it, you can find it. And Daniel is giving you an education which begins from Article 14 of the 1992 Constitution, where what we call your Miranda rights are. That when the police comes to arrest you, first they will identify themselves and they are supposed to tell you in a language that you understand. Note that it's in Article 14, very clear. In a language that you understand, why they are arresting you. Now, after telling you about that, they will tell you your right to a lawyer of your own choice. And that you are at liberty not to say anything, because anything you say can be used against you in the courts. He says, if the procedure departs from this, you can resist the arrest if you have the power and the energy to do so. But he mentions other things. Please emphasize for us so that our audiences will be clear and not be misled by some commentary we are seeing in the public.
Thank you very much, Samson. What we are talking about essentially is that you don't have the right as a criminal suspect to deny the allegation at the time you are being arrested. You cannot deny it. Nobody's asking whether you have committed it or not. The police officer says that I am investigating this particular crime or allegation against you, and you are under arrest because your presence will be needed to answer questions. You don't dispute it. You don't deny it. What is essential here is that the law or the procedure relating to arrest is strictly followed. And that procedure is just as you just mentioned it. The police will put the suspects under lawful arrest to say that you are under arrest. When you hear that from a police officer, the law has really placed you under arrest. But what must follow is that the police would have to tell you that I am arresting you for so and so offense. And the explanation must be in the language you understand. And the police must tell you that you have the right to a lawyer. You are not obliged to say anything to me, to explain anything to me until your lawyer is here. All these procedural steps must be complied with for an arrest to be lawful or legal. Now, when these steps are not followed, and the police officer just uses force to touch your body or to bring you under physical submission, clearly the police officer is violating the procedure of arrest. Okay. And that is where the law gives you the right to try to resist that arrest. Now, the resistance could be in the form of seeking to know why you are being arrested. Please let our audience get this very clearly.
It must not necessarily be violence.
You don't start using violence against the arresting officer. What you do is that, can you please tell me why you are arresting me? You can insist on this as many times as you can. You are demanding to know why you are being arrested. And the arresting officer is under duty to explain to you the reason for the arrest. Imagine
the arresting officer is not explaining. It's not listening to me. What should I do?
Now, if the arresting officer fails to explain the reason for the arrest, then the arresting officer has violated the law in the first place, the law relating to arrest. And that violation is a violation of the suspect's fundamental human right, for which the suspect can even sue him later. But at the point of arrest, what can the suspect do to vindicate this right of his? What can be done is that the suspect can say that, well, if you fail to explain to me, I will still follow you to the police station. I will still follow you. In fact, this is an option of prudence. It's an option of prudence. The suspect may decide to follow the arresting officer, but the suspect can also insist that until you tell me what I am alleged to have done wrong, I am not following you. And the suspect at this point, in the face of the failure of the police to explain, the suspect can use every physical means to overpower the police officer, to overcome that unlawful arrest. And we have seen in our case law where a suspect brutalized a police officer and kicked him on the ground and tore his uniform apart for, unlawful arrest. So a police officer who unlawfully arrests a suspect places himself at risk of being physically opposed.
Are we referring at this point to Asante versus the Republic?
Asante versus the Republic, which is a very famous case.
Good. So give us an idea how exactly what took place for the court to say that the gentleman was right by resisting the arrest and kicking the police the way he did.
Now, the arresting officer in the first place did not explain the reason for the arrest. When you fail to explain the reason for the arrest, it means that you are arresting or seeking to arrest without a reason. And so the citizen in that circumstance can demand that I am not going with you. Now, when the arresting officer used force to arrest the suspect was able to overpower the police officer, and in the course of the struggle, he kicked the police officer on the ground and dragged him on the ground until his uniforms got torn. And he was arraigned before the court for causing unlawful damage to state property, which is the uniform, and assaulting a police officer. But the court was very clear that if a police officer is arresting a citizen, the reason for the arrest must be clearly stated or communicated to the citizen, so that the citizen will know that, yes, I have heard the reason for my arrest, and I am under legal obligation to submit myself to the arrest. Now, the legality of arrest depends on notification of the purpose of the arrest. I take it again. The legality of an arrest in criminal law depends, first of all, on the notification of the purpose of arrest to the suspect. And the notification must be that the suspect has committed or is alleged to have committed a crime.
And you have explained that already. And as he says, it doesn't mean that you do not have a right to deny that you have not committed the offense. At the time when the police officer has come to arrest you, that is not the time to deny. Because once you are explained to and you have been told of your choice to a lawyer, and then you call your lawyer if you have one, or once you get to the police station, you will now be made to write your statement.
Your statement, yes.
That is the point where you have the opportunity to say,
deny the allegation.
Exactly. So we are not saying that you don't have a right to deny that you have not committed the offense for which the officer has come to arrest you, except that the fact that you have not committed the offense is not a basis for resisting the arrest lawfully. And Daniel says something, the things he's saying, they are in the law, but we're trying to break things down to you, and so you don't hear him quoting. So in section 3 of our, what you call the Act 30, is the procedure. It says arrest, how arrest is made. It says, in making an arrest, the police officer or other person making the same shall actually touch or confine the body of the person to be arrested. Note that the police officer or the other person shall actually touch or confine the body of the person. Remember, he says it's not only the police who can arrest. Even you, a citizen, you have the right to arrest, what we call citizen arrest, except that there are rules about that. If you arrested somebody because they are committing an offense in your face, and you could arrest them, once you arrest them, immediately you see a police officer or you see the nearest police station, you hand the person over. You don't take things in your own hands. So he says you should actually touch or confine the body of the person to be arrested. And Daniel emphasized this. Unless there be a submission to the custody by word or action. So unless the police officer says you are under arrest and you say, I submit, where do you want us to go? Let's go. The police officer has identified himself, explained to you. If you don't submit, then they will touch you and try to confine you to ensure that they have succeeded in their arrest. Let me go to Sami for a brief, commentary around this about what potential offenses can one be committing when they are trying to resist arrest and their resistance is unlawful. What are the potential offenses that they could commit?
Thank you. Thank you very much, Samson. If you try to resist an arrest, you are likely to commit the offense of obstruction of justice. And that is in itself another criminal offense that you could face, I think, a minimum of about a fine and a jail term of, let's say, not less than, I think, 1 year or so. So if you try to resist an arrest, that in itself is also a criminal offense. But I want to say something. I think the reason
if you
why
try to resist an arrest unlawfully, if the resistance is unlawful, that's what you mean, correct?
Be it unlawful or lawful, you could be placed in the circumstances of obstruction of justice. Okay. And it doesn't even have to be the person resisting the arrest, even bystanders, people related to the person. And if you take a politician, it could be any of the foot soldiers or sympathizers who might be putting hurdles or impediments in the way of law enforcement to be able to arrest such an individual. Then you'll be causing what we call obstruction of justice. And that in itself is a serious offense for which you can go to jail for not less than 2 years and not more than 4 years. If you take, for instance, the Office of the Special Prosecutor Act, obstruction of justice places you in that category of sanction, which is minimum 2 years, maximum 4 years. But I wanted to also make this submission that often I know that because the wording has always been the use of police, many citizens tend to think that those who are not properly so-called in uniform and who are effecting arrest are also not police. So that is the correction I wanted to say. So if you take agencies or institutions like the Office of the Special Prosecutor, Economic and Organized Crime Office, as well as the other intelligence agencies, you realize that they also enjoy police powers, and they also have the power to arrest. So when we say a police officer, it does not strictly mean the police officer that people see in uniform, but also all other agencies, whether by an act of parliament or even if directly from the Constitution, who have been given a law enforcement mandate, also fall under this same category of things that the police can do. They can also
so law enforcement agencies like OSP, IOCO have police powers, correct?
Yes, they have full police powers.
Great.
Which means whatever the police is able to do to you as an individual or as an organization, these organizations can also do the same when it comes to arrest or search or any of those other actions that the police usually would do.
Yes, but you were going to say that even where the arrest is unlawful and the person who is being arrested resists, they could still become subject to obstruction, obstructing the police in the performance of their duties, or obstruction of justice, and they could be tried for that. I don't understand.
But not just obstruction of justice, but how do we call it? Conduct that could lead to breach of the peace. I'm just saying that in the course of all these things, whatever your action could come with consequences, and charges can be filed against you in that regard. Of if your behavior is so insulting,
correct,
is about to breach the peace and all that, you could be charged with these other offenses, and not necessarily because the arrest was unlawful.
Right.
Be that as it may, I'm taking it from the point that any authorized officer will typically come to you following procedure. But even if they don't follow procedure, I'm saying that some of your actions may also fall into category of offenses that you may not even be aware of.
Right. And please, viewers, Sami just said something that you also have to pay attention to. You see, if you insult the police, or as he said, not just the police, but persons who have police powers to do their work, like officers from the IOCO, officers from the OSP, you could be charged for an offense and you could go to jail for the conduct of insulting. You are not supposed to do that. Once they are doing the right thing, you are not supposed to do that. So insulting them can actually get you into trouble if they are doing the right thing. And Daniel had explained that once you submit yourself, there is no need, or even if you don't submit yourself, the force that they have to use must not be too much. Section 6 says, the person arrested shall not be subjected to more restraint than is necessary to prevent his escape. And it is headed, no unnecessary restraint.
Yes.
how do I know that they are putting, you know, a force or restraint on me, which is abusing or above what the law allows?
So it's quite difficult for you as a person to know, but we are all reasonable beings. And when that's why we even have an adage that if you are using a hammer to kill a mosquito, straight away, any reasonable person will know that this is unreasonable, holding a hammer to kill a mosquito. So if law enforcement agencies are about to effect an arrest and they use force more than necessary, I think that it's a question of fact. And when we say a question of fact, it means that from the circumstances, any reasonable person will know that it was more than necessary. But let me also state that it is not always the case that law enforcement agencies will arrest you in your home or workplace or on your way to work. Sometimes you are simply invited to their offices, and then an arrest is made in the office. Often people do not take that to be more serious as in when they come personally to you to arrest you. But there are so many ways a person is arrested. And if you take the office of the special prosecutor, for example, majority of the time, they do place people under arrest when they have invited them. So you hear people say, but they invited me, I went to them and they said that they've arrested me. Yes, that is also a form of an arrest. You can be arrested right there in the offices of the law enforcement agency, and they will go through the procedure.
The invitation is trying to make the arrest decent.
Exactly.
Trying to make it nice.
Exactly.
Okay.
So, but often people, in a way, look down upon that and come out to say, well, they said I've been arrested, I've been granted bail. You are under arrest just as if they had come personally to your house, to your office to effect that arrest.
They are just being courteous to you. Thank you. Now, Daniel, I want just a minute around this. In Section 5 of the Act 30, it says power to break out of any house for purpose of liberation. Any police officer or other person authorized to make an arrest may break out of any house or place in order to liberate himself or any other person who, having lawfully entered for purposes of making an arrest, is detained therein. It sounds to me that the law is expecting that some people can put the police officer in trouble.
Yes, something, thank you very much. The meaning of Section 5 of Act 30 is that there are instances where, in trying to arrest a person, the police may lawfully enter a place like a house or a building or an office or any enclosed place to effect the arrest. But we are very much aware that many enclosures or many enclosed places have doors, lock, and keys. So when the police officer enters your house lawfully, I emphasize lawfully, to effect an arrest, you cannot go behind him to quickly lock the door and tell him you are not going out of this place. When you do that, you are unlawfully detaining the arresting officer. And the effect of Section 5 is that it gives the arresting officer the power to break out of that house, the power to destroy the door, the power to destroy the lock and the key in an attempt to liberate himself. You see, the wording of the section is very key because it uses some key terms or words. Example is liberate. The word liberate there connotes that the closing of the place constitutes an unlawful restraint of the arresting officer. And so we can say that the arresting officer has been unlawfully detained. And so there is a need for liberation at that moment.
Thank you very much, gentlemen. Gentlemen, now let's get ready to go to this, zoom into this other part. You would see that whether one can resist arrest or not lawfully was actually the last part of how we frame the topic for discussion. But we decided to deal with that one first. And by dealing with how you can lawfully resist an arrest, we have educated you on how arrest is done, how it will be lawful or how it will not be lawful. The problems you can get yourself into if you attempt to resist and you resist unlawfully. So, Sami, for a minute, what will you say about if you have come across this publication where someone is saying, if you come into my house to arrest me without a warrant, I will shoot you. It's on Ghana Web. The individual making that claim. What will you say to a person like that?
Well, it just means that the person is inviting the entire cohesive machinery of the state into that person's abode. And I'm not sure an individual can withstand that cohesive power of the state. You will be overpowered. And if you're not careful, you will even lose your life. I would say that it's wrong and it's even unlawful to say that, because law enforcement agencies like the Office of the Special Prosecutor, IOCO, and Ghana Police have the power to arrest with a warrant and without a warrant. The same thing also goes for searches. They have the power to search with a warrant and without a warrant. What this means is that there are circumstances under which we do not need a warrant from a court to be able to enter into your premises. And those circumstances are provided for by law. So if you go to Section 10 of Act 30, you find the circumstances under which you may be arrested without a warrant. And the circumstances are very interesting. They are almost the same as the ones with a warrant, because it says that if a police officer may arrest without warrant any person he suspects upon reasonable grounds of having committed an offense, of being about to commit an offense, where he finds such person in a highway, building, or other places. So these are just 3 out of about 10 circumstances under which the Office of the Special Prosecutor can arrest you without a warrant. If we have reasonable grounds to believe that you have committed an offense, that you are about to commit an offense, or you are about to commit an offense at a particular place, and several of them, including when you are obstructing us from doing our work, or you commit an offense in our presence, then we can arrest you. So it's never true that a law enforcement agency cannot come and arrest you if they don't show you a warrant. Please. And I think that this education is very important, because people are thinking that you only have to show a warrant before you can enter into their premises to either search or arrest them. And we can also enter into your premises to search without a warrant if we have reasonable grounds to believe that if we don't do that immediately, the item that we are looking for could be concealed, or it will be lost, or it will be destroyed, or something else could happen to the evidence that we are looking for. Then we can come into your house and enter your house and search your premises. I'll give an example that had to do with...
Let me notify our viewers. As you can see, we have been scrolling the specific provisions of the law that allows the police or law enforcement agencies who have police powers to effect an arrest without a warrant. Now, Sami has also mentioned they can conduct a search without a warrant. The conditions under which they can effect arrest without a warrant, we have scrolled it for you to see. The conditions under which they can also conduct a search without a warrant, as he just said, we will also put that one on for you to educate yourself. Please go on and share that with us.
Yes. So, as I said, we can conduct a lawful search without a warrant. And as I said, we have done one before, and one that just comes to mind has to do with the former Minister for Sanitation, Madam Cecilia Dapa. The OSP did conduct what we call an emergency search upon arrest of her into her houses to search for tainted property. And we were able to do that without a warrant. And that does not make the search unlawful. It's simply law enforcement agency exercising a right that has been given by law. I understand that emergency searches or searches that are done in order to avoid tainted property being concealed or things being hidden may be abused. But despite the abuse, you cannot also say that it is unlawful, and that at every material time when law enforcement agency comes to you, they must show you a warrant before they can search you. And I think that education is very, very important for us to make.
Right. Also, the provisions about when the police or officers of law enforcement agencies who have police powers can search without a warrant. The provisions are being shown to you. The first one on arrest was Section 10 of what we call the Act 30. This one we're showing you sections 92, 93 to 94, 5 thereabout. Let me go to Daniel now. Daniel, help us fill in the gaps, or from your perspective, when can the police or those so empowered arrest without a warrant or search without a warrant? Do they need to be officers of a certain rank and so on?
Thank you very much, Samson. Let me first deal with the power of search. The police, when they arrest any suspects, have the power to search the person. There are two kinds of searches. The first is when they have arrested you and they are searching your body to see if there is anything concealed on your body. They can do that at the point of arrest. It could be on the highway or anywhere. Now, the second type of search is searching of your home or any building or any vessel, any carriage. That one, the police can search you with a warrant given them by a magistrate or by a judge. But just as Sami said, the police or any arresting officer can search any home, any place where the exigencies of the situation demand that such a search should be conducted. And even though the law does not define what an exigent situation means, I associate myself with Sami's views that where the officer is of the view that there's a likelihood that something very important may be concealed or further criminal offense may be committed in relation to a particular thing, a search may be conducted without a warrant, So viewers may look at section 88 of Act 30 on search by warrant and search without a warrant. So we can do this.
On search without a warrant, we just put up the provisions there. But if I may just read section 93, it says that search without a warrant in certain cases where articles are being conveyed, etc. Whenever a police officer has reasonable cause, and when we say police officer, it includes officers of law enforcement agencies that have been given police powers, like IOCO and OSP. Whenever a police officer has reasonable cause to believe that any article which has been stolen or otherwise unlawfully obtained, or in respect of which a criminal offense has been, or is being, or is about to be committed, is being conveyed or is concealed or carried on any person in a public place, or is concealed or contained in any package in a public place, the purpose of being conveyed, then and in any such case, if the police officer considers that the special exigencies of the case so require, he may, without a warrant or other written authority, apprehend, seize, and search any such person, package, or article, and may thereupon take possession and detain such article, together with the package, if any, containing blah, blah, blah. It's plenty, and all of that in one sentence. So, restate again, you dealt with the search. How about the arrest?
Now, when we come to arrest without a warrant, it is a matter of emergency for the police or the arresting officer to do that. Arrest without a warrant. It could be done by a private person, and it could be done also by a police officer. Now, let me emphasize that before a police officer can arrest without a warrant, under Section 10 of Act 30, the police officer must satisfy himself that the suspect has committed an offense in his presence, or that he has obstructed the police from executing their duty, or that the suspect is trying to escape or attempting to escape an arrest, or he's in a possession of some implement that may be used to commit a crime. So it deals with the police officer satisfying himself on reasonable grounds that this person has committed or is committing an offense. He must have personal knowledge of that one. Now, when it comes to arrest without warrant by private persons, that one is very narrow and very strict under Section 12. If I may just take a sentence of that.
Yes, go ahead.
A private person may arrest without a warrant any person who in his presence commits any offense involving the use of force or violence, or any offense whereby bodily harm is caused to any person, any offense in the nature of stealing or fraud, or any offense involving injury to public property. It is important to note that for a private person, you cannot arrest without a warrant unless the offense is committed in your presence. And for a police officer, when there is a reasonable ground that you have committed or you are about to commit, the police officer or any arresting officer may conduct or effect an arrest without a warrant.
Asking the question also about whether there's a need for that officer to be of a certain rank, either for a search or for an arrest. Any one of you can take it up.
Yeah. When it comes to, strictly speaking, the police service, then it has to do with the superintendent. Any officer of, I think, that rank and above or so could do that. But when it comes to the other law enforcement agency, once the head of the agency has given authorization to a person, then that person can do so without a warrant. So that is what I can say in respect of that. But I also wanted to touch on a certain subject, a particular agency, which is the National...
Wait, hold on, I'm coming. And in Section 94, it says that search of premises without a warrant, any police officer not below the rank of assistant superintendent of police, or who being below such rank is authorized in writing so to do by police officer not below such rank. So first, you must be a police of a rank not below assistant superintendent to be able to search without a warrant, or that an officer of that rank has in writing authorized you to do so. When it comes to organizations like the OSP and the IOCO, it will be the director who will write that kind of authorization. So if you come to me to search without a warrant, I need to ask you of your rank. And if your rank is not above assistant superintendent of police, then I must ask you to show evidence of authorization to do the search. Is that it?
That is correct.
Exactly that, Samson.
Okay. So if they are trying to say, I don't have anything to show you, I should hold them to it, that they must show me. Now, Sami, quickly, you are going to the other part. I think that is about those institutions that do not have police powers, correct?
Well, I think they also, most institutions have police powers, but I was just saying that because of how Parliament worked on the new act of the the Security and Intelligence Agencies Act, Act 1030. It made the National Investigation Bureau, it took away some of the things it could do as formerly called BNI. And currently, the way the law has been structured, if you look at their law and you go to section 34, which talks about warrants, it makes it look like the NIB cannot arrest or search without a warrant at all, unlike the way police, EOCO, OSP enjoys without a warrant. For them...
But we understand that in their operations, they are actually not supposed to keep a force. So in their operations, they use police officers, right?
Not necessarily. They themselves are also able to do that even without a police officer.
Okay.
But the point being made is that Act 1030 slightly changed how they are supposed to behave. Act 1030 made them appear more like an intelligence agency and a little bit of law enforcement. And even for the law enforcement, if you read their act, if you read section 12(1)(g),
right,
it says that they can conduct investigations in collaboration with relevant security agencies. But the point I'm trying to make is that for them, there's a little bit of an exception which says that at all material times, they must produce a warrant. And the warrant, they can obtain it from a police officer of the rank of a superintendent and above, or from a judge or from a tribunal. But for them, at all material times, they need to display a warrant to be able to do the things that police or the other agencies will typically do. And I must say that
when they are coming to effect an arrest and they come with a police of a certain rank, they will not need it. Is that not correct? They will not need it.
I'm having a little bit of a challenge, and I can explain the challenge to you is that I'm saying that on their own, they are also an agency, and they can do everything that they can do in terms of collecting intelligence or thwarting security threats, or when they are collaborating with us, yes.
Okay.
But if they are not collaborating with us and they themselves so much are, say, doing a particular work and they need to search or arrest, then they need to come with a warrant, either granted to them by, say, a senior police officer or by a court or by a tribe. That's what I'm trying to make. But if they are working together with another agency, then of course they don't need to produce it.
So gentlemen, we are running out of time. So I need us to go straight to MPs, members of parliament. The law in Article 117 and 8 thereabout says that when they are on their way to, attending at, or returning from parliament or the business of parliament, they are not subject to service of criminal processes and so on, or civil processes or so on. Does it mean that without recourse to the speaker, they can never be arrested? Yes, Daniel.
Thank you very much, Samson. Article 117 says that a civil or criminal process coming from any court or any place out of parliament shall not be served or executed in relation to a speaker, the speaker or a member of parliament or the clerk of parliament while he is on his way to or attending at or returning from any proceedings of parliament. Now, what it means is that when an MP specifically is undertaking parliamentary work, like when he's going or when he's returning from parliament, no legal process or even arrest can be conducted in relation to that person. And when you go to the standing orders, Order 24, it makes it clear that processes are to be served through the MP, through the speaker. If they are supposed to be served on a member of parliament or the clerk of parliament, it must be served through the speaker of parliament. And when this is not done, and it is served on the MP directly, when he is attending to parliamentary proceedings or when he is returning from parliament, that service is clearly wrong. And when the speaker is notified, the speaker can return the service to the registrar of the court that issued it.
An MP is engaged in a fight on his way to parliament. or he's hit and killed somebody, or he's pulled a gun and shot somebody, the police cannot arrest him?
Samson, the immunities or the privileges under the Constitution for MPs are exceptions to the normal enforcement of the law. So once the MP is going into Parliament or returning from Parliament, the law says that no legal process can be effected against him. So if the police officer is aware that this MP is going to Parliament, but is of the view that that MP has committed a crime in the process of going to Parliament, the proper thing to do is for the police officer to notify the speaker.
Okay, thank you. Because we are running out of time, Sammy, I've got just a minute for you. What can you say about this? Must we always go through the speaker to be able to arrest an MP or serve an MP with a criminal process?
I'll be short and go the other way around. I think that we like drama too much in this country. No need to reinvent the wheel. I think we went through when it had to do with Xavier Sosu, and we talk extensively about this. Parliament does not sit the entire year. And even in the entire year, they have times they sit. As a law enforcement officer, if I want to arrest an MP, I'm going to arrest the MP when he's not on his way to attending to Parliament or coming from Parliament. I think we must go about this and find better ways to be able to arrest them. I will be able to arrest an MP when he's not on his way. And I'm saying that law enforcement agency, we must find a way to be able to circumvent this. But then if we need to go through the procedure, yes, we need to go through the procedure, because even the president is immune from arrest. MPs have a form of immunity, which is that when they are doing parliamentary job, don't interfere. But I'm saying that they don't do parliamentary job 24/7, 365 days in a year. Thank you.
So, Daniel, at 10 p.m., when the MP is sleeping in their house, even though he has returned from Parliament, they can arrest the MP from his home?
Yes, once he is not involved in parliamentary work.
Okay. All right. Thank you very much. Daniel Krang and Sammy Dako. Daniel Krang is a private legal practitioner. He is based in Sunyani, and he's authored several books on criminal law particularly. And Sammy Dako is also with the OSP, is also a lawyer. Thank you also very much. I actually intended to open the phone lines for you to join in this, but unfortunately, time did not allow us. This is the law, it is your help law, and it is your legal light. I'm Samson Ladia Yenini. I hope we have been helpful to you.